DUI and refusing a Sobriety BAC test under the Implied Consent Law, Part 2. Declining a BAC test. Even if you are not ultimately charged with or found guilty of DUI, you will still face consequences if you refuse to undergo a breath, blood, or urine test because of the implied consent rule. State-by-state variations exist in these sanctions. The number of drivers who refuse BAC tests in a state each year is a good indicator of how severe that state's implied consent sanctions are. Around 20% of all drivers nationwide who are pulled over on suspicion of DUI refuse to take a blood alcohol test, according to the NHTSA. According to state statistics, refusal rates range from 2.4% in Delaware, where there are significant sanctions, to 81% in New Hampshire, where penalties are relatively mild. Whatever the penalties are in your state for refusing a BAC test, be aware that doing so won't likely prevent you from getting a DUI conviction. Refusing a test is taken as evidence of guilt because it is presumed that an innocent individual would consent to a test because they have nothing to conceal. Enforce refusal to accept. In an effort to escape a DUI conviction, a driver who is aware that they would fail a BAC test may decide to accept the consequences of doing so. Many states have implemented no refusal enforcement rules to address this issue. Where these regulations are in effect, police officers may ask a judge for a warrant allowing them to administer a BAC test without the suspect's permission. In the foolish belief that their blood alcohol level will have decreased by the time an officer can obtain a warrant, drunk drivers frequently resist breathalyzer tests. Today, the majority of law enforcement personnel can quickly get electronic warrants using their mobile devices. Even after a warrant has been acquired, someone who refuses to take a breathalyzer test will probably be charged with contempt. In the end, they will still be detained and a blood drawn for a BAC test. It will be taken by force if necessary. Refusal of a BAC test penalties. Refusing a breath test in violation of implied consent may result in fines, automatic license suspension, or complete license revocation. If the person who refused the test is subsequently found guilty of DUI, their failure to cooperate will probably result in higher penalties. If you refuse a breath test, the following things could happen in various states. Florida, a license suspension that is automatic and lasts up to a year. Texas, up to 180 days automatic license suspension. In New York, there is a $500 maximum fine and an automatic license suspension of up to 6 months. Massachusetts, a permanent license revocation if you are found guilty of DUI and an immediate license suspension of up to 6 months. Currently, when a driver declines to submit to a breath test, 42 states automatically suspend or revoke their driver's license. This means that by refusing the test, the police officer who pulled you over is free to immediately confiscate your driver's license. Obeying laws requiring implied consent. Driving is not a right but a luxury. You should consider signing your driver's license forms as getting into a contract with the DMV and local law enforcement. You made a commitment to follow the law, drive defensively to protect other drivers and property, and assist anti-DUI enforcement efforts in exchange for your driving privileges. Refusing to submit to a BAC test in violation of that agreement is a serious offense, and your driving privileges could be suspended as a result. If you are stopped on suspicion of DUI, refusing a test may seem like a wise decision, but it will always worsen the situation.